Good morning,
Good morning.
I have one witness in this case.
Good morning. Are you Jonah Ray Johnson?
Yeah, Mom.
And this is 25 DCCR 1775. Mr. Johnson is charged with.
Right away, the judge is signaling something important here. This is not a clean slate hearing. When a defendant walks into court with 9 prior arrests in 5 years, every decision afterward gets filtered through one question. Can this person actually be trusted back into the community? And you can already feel the patience in this courtroom running dangerously thin.
Aggravated assault with a deadly weapon. And Mr. Vasquez has filed a motion asking that I reduce Mr. Johnson's bond, which is currently set at $300,000 in that case. Are you calling your client?
Yes, Your Honor.
Mr. Johnson, best you can, raise your right
Oh,
hand.
no, I'm sorry, Your Honor. I'm not. I'm calling my client's mom, Jacqueline Broussard.
Ms. Broussard? Mr. Johnson, if you'll just come around just to the side, right there on the corner. Ma'am, if you'll come right over here, please. Good morning. And would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You may proceed.
Thank you, Your Honor. Ms. Broussard, state your name for the record, please.
Jacqueline Broussard.
And you've done this before, haven't you?
Yes, ma'am. Oh, sir, I'm sorry.
And you are Jonah's mom, correct?
Yes.
And the original bond back in September was $150,000. Wasn't that correct?
Yes, sir.
And what went wrong? What was the problem there?
The ankle monitor. We thought it was broken, which that we was late. That was, we called Johnny, and Johnny told us to come in. Which we had been talking with Johnny for 2 weeks. But like I say, Johnny said come in, and then something's going on with the monitor. And we also was a payment behind.
Okay.
But we like.
I'm
sorry. Go ahead.
That's all right. The bondsman said the defendant has failed to pay for the GPS device. It wasn't charged. He will not respond to surety's attempt to reach him. He cannot be located.
This is where bond hearings get incredibly technical. The defense is trying to frame the GPS issue as a misunderstanding, maybe faulty equipment, maybe missed payments. But prosecutors hear something completely different: noncompliance. And in bond court, even small violations can snowball fast because judges see them as warning signs for future behavior.
Surety feels like his bond is at risk. Now, you disagree with that, right?
Yes, sir.
The bond was never at risk.
No, sir.
Jonah lives with you.
Yes, sir.
You live in Beaumont
Yes, sir.
with your husband.
Yes, sir.
And how many people live in that house?
Me, my husband, my oldest son, and John.
And how long have you been in that home?
Over 5 years.
And the 4 of you lived there.
Yes, sir.
Was Jonah working when all this happened?
Yes, sir.
Where was he working?
He was working for Jefferson. Nursing home.
Say again?
Jefferson.
What was he doing?
He was working in the kitchen.
And how long did he have that job? You recall?
I think he had just received that one over there. Maybe 6 months. I don't know. Yeah. Because he just got hired out over there.
And he's 18?
Yes.
He lives with you. He's not. Is he a flight risk?
No, sir. He's not.
Are you worried about him taking off or running
No,
off?
sir. I'm not.
And you wouldn't waste your money if you.
No, sir.
What bondsman did you talk to?
I had talked to a professional with Kenya, and I had talked also Avery with Lisa.
Which bondsman was this back in September?
I think that was Ella.
That was Ella. Is that who you're talking to now?
Yes, one of them, yes.
And what have your conversations been like with them?
They just ready for me to get in touch with them and see if they're not going to be reduced. I just had one text me this morning.
Have you talked to them about what amount you would want that you're trying to get reduced to? What would be reasonable?
Lisa.
Notice the strategy from the defense attorney here. He's building what lawyers call community ties, stable home, lives with parents, steady job, not a flight risk. Basically, he's painting the picture of someone grounded enough to return to court. Because bond hearings aren't about guilt or innocence yet, they're about risk.
We had talked on that.
Well, it was 150,000 back then,
Yes, sir.
so it's not really realistic that that the court would drop to 100,000 now.
Mm-hmm.
Are you asking the court to reinstate I don't know, reinstate the correct word, but to go back to the $150,000?
Yes, sir. Yes, sir.
Is that something you think you could work with?
Yes, sir.
They probably want you to sign a contract for $15,000.
Yes, sir.
I think 10%
Yeah,
of the order.
yes, sir.
Would you make sure there was no discrepancies or mistakes or misunderstandings about the GPS monitor system?
Yes, sir.
And what else would you like to tell the judge? About the bond.
I got the one. We are ready prepared to make fun. So,
Have you seen the video in this case?
yes, ma'am.
Okay.
I have talked to my son. Yes, yes, ma'am.
You've actually
In the-
seen it.
Yes, ma'am.
Okay.
The whole video.
Okay. Anything else?
Nothing else. Right?
That was
Questions of this
that was
witness?
actually one of my questions I was going to ask this witness is whether or not she's seen the video, Judge.
Okay.
In addition to that, Ms. Broussard, are you aware that your son in the last 5 years has been arrested for 9 different offenses?
Excuse me?
Are you aware that in the last 5 years your son has been arrested for 9 separate offenses?
9?
Yes, ma'am. Evading arrest as a juvenile, UUMV as an adult, possession of a controlled substance, unlawful carry of a firearm, failed to ID, possession of a controlled substance, possession of marijuana, and 2 additional unauthorized carrying of a weapon. Were you aware of those arrests?
Yes.
Okay. Now, the gun that your son allegedly carried back on August the 31st of 2025, during that shootout at the Pine Club Apartments, do you have any idea where you got that gun from?
No, sir.
Are you aware that a bystander was shot during that melee?
Yes, sir.
All right, that's all I have, Judge.
Okay. Any other questions of this witness?
No.
Thank you, ma'am. You can have a seat.
Thank you.
Yes.
Any other witnesses, Mr. Vasquez?
No.
Mr. Holman?
Judge, one of the items of evidence that I planned on introducing was the video from the shootout. It sounds like the court vividly remembers that. So if the court doesn't wish to see that again,
And then comes the prosecution's hammer blow. One by one, the prior arrests get read into the record like a checklist of escalating problems: drugs, weapons, failure to identify, firearms. You can almost feel the atmosphere change in the room. At this point, the state isn't just arguing missed GPS payments anymore. They're arguing ongoing danger.
I wonder.
Let's just quickly play it. I want to, I'm refreshing my memory by taking, well, first of all, I'm going to take judicial notice of the court's file. I have reviewed the probable cause affidavit, which is what reminded me of the facts of the case. And I guess it was the other
It was the
case that
co-defendant.
we had a bond hearing on. Is that
Yeah.
correct?
Well, no, I take it back. It was this defendant when he was represented by Brittany Holmes, if I'm not mistaken.
So I've had a bond hearing, watched the video on this case.
Yes, Judge, if I'm not mistaken. In fact, when you look at my notes, that would have been January 13th of 2026. My notes include that there was a defense motion to reduce the bond. We argued, you heard evidence and testimony, and that you denied the motion back in January of this year.
So this was after the AFRS, and the bond was at $300,000 on that date for the same bond hearing.
Yes, Judge.
Your motion's denied. I've already heard all the evidence.
If there is something, Judge, I think that it's at least, if you're going to deny it, I think you may want to consider it as far as whether or not the bond is sufficient. As it states, it's just a 5-minute clip of
Go ahead.
a jail phone call that I've added subtitles to. If I could do that, I'm happy to bring my sponsor witness, but if you'll stipulate to it.
No, I'm going to object to it to relevance.
Bring your witness, please.
State calls Captain Michael Palmer.
Good morning, sir. Thank you for your patience this morning. If you'll please raise your right hand, do you swear or affirm the testimony you're going to give in this hearing?
Oof. That denial came fast. And that tells you something huge. This judge already made up her mind before today's hearing even started. Once she reminded everyone she had already watched the shootout video in a previous hearing, the defense was climbing uphill. In court, repeated motions without major new evidence can irritate a judge more than persuade them.
Be the truth, the whole truth, and nothing but the truth.
Yes.
Thank you, sir. Go ahead.
Captain Ponder, would you state your full name for the record, please?
My name is Captain Michael Ponder.
And Captain Ponder, very briefly, what do you do? What are your duties at the jail? Over the jail? That's right, department.
I'm the custodian of records for the Jefferson County Correctional Facility.
And you're familiar as a custodian of record with the recording equipment there at the jail, correct?
Yes, sir.
And it's capable of making an accurate recording.
Yes, sir.
Each inmate is issued a unique identifying number, correct?
Yes, sir.
And that's one of the ways to identify who makes certain calls from the jail, correct?
Yes, sir.
Have you had an opportunity to review what I am marking? Judge, you want me to mark it for states 2 or 3? We entered one in the first hearing back in January. I can do it 1. How are we going to do it?
I think, it's technically a new hearing.
Okay, I'll do 1. Okay.
One's fine.
All right. You recognize this USB drive?
Yes, sir.
How do you recognize it?
Because I listened to it this morning.
And are these your initials in today's date that's on the USB drive?
Yes, sir.
I'm marking it as State Exhibit number 1. You listened to it. Do you have any doubt that it's a fair and accurate copy of a jail phone call or recording of a telephone call made by an inmate, this inmate, from the Jefferson County Jail?
No, sir. No doubt.
All right, Judge, state off state. State.
Mr. Vasquez?
Good morning. How long is this video?
This is
the
an audio.
recording,
I'm sorry, the audio.
It's about a 5-minute excerpt from a 14-minute and 20-some-odd second phone call.
Well, so it's been altered.
It's been included, yes.
Object to the alteration, Your Honor.
Judge, what's on here is the original 14-minute long video as well as the shortened 5-minute video with the subtitles added. So the original's on here.
Okay.
And by the way, I gave it to Mr. Vasquez yesterday, and he's had a chance to preview it.
States 1, with both, will be admitted.
Permission to post, Judge.
Yes.
Judge, can I finish my objection?
Sure.
Object to the alteration, and then there's a transcription. I object to that as hearsay, where you have
The subtitles.
the subtitles of what you think they're saying.
Do you disagree that the subtitles are correct with what you hear?
I don't know, Your Honor. I just object to it being hearsay.
How is it hearsay?
The subtitles are on it to what someone has written in what they've transcribed the conversation to be. I object to that as hearsay.
Mr. Coleman?
Judge, if the audio is not hearsay, which is a statement made by a party opponent, then the subtitles are therefore not hearsay. Judge,
Obviously, we'll be able to listen myself, and your objection's overruled. It's admitted.
permission to publish it.
Yes, and that's both the excerpt as well as the entire. And thank you, Captain Ponder.
Yes.
Monitor, you reported or monitor.
Came back in. Still ain't her. She was like, you got right up to me, jumping me, and I'm going to cheer you up. But she got down and gave up.
This is a sneaky but important courtroom fight happening right now. The defense is attacking the subtitles, not necessarily the phone call itself. Why? Because if the jury, or in this case the judge, reads words on screen, those captions can shape how the audio gets interpreted. Prosecutors know visuals hit harder than muffled jail audio ever could.